The mother has no problem with visitations occurring in Tennessee. No problem at all. So while it's a suspension of visitation, that would be for purposes of outside the state of Tennessee. Your Honor, we're before this court asking to suspend visitation pending a final hearing in this matter. Petitioner in this case has had the minor children in her care and custody solely since February the 20th. The father has not exercised his regular and routine visitation during that time period. I will say that the mother has offered, when the father has come into town, to allow him, his regular visitation, which he has exercised, and things have gone fine. She has asked, based on the fact that the stepmother has not submitted herself to the Department of Children's Services to complete all the tasks required of her, that the stepmother not be involved during this process. Department of Children's Services opened up a case on this matter when it was reported that the minor child was being pinched on his penis by the stepmother. It was reported and DCS investigated. DCS required several things of the father and several things of the stepmother. To my knowledge, father followed through with what he was required to do. Stepmother did not. Stepmother moved to Florida, and DCS had to close their case because stepmother was outside the jurisdiction of the Department of Children's Services. Regarding the main crux of this is that pursuant to the relocation statute, the father was to give notice of the relocation, which I will give him credit that he gave most of the criteria on the relocation notice. But when the mother, by and through counsel, expressed that there was an objection to his relocation, he still relocated without leave of the court. The court did not give him permission to leave, and so we're before this court now asking about potentially changing a parenting plan in the interim, which a relocation is the only exception that you don't necessarily have to show irreparable harm, though I've alleged it in my motion. You don't have to show irreparable harm in order to change what the visitation arrangement is. Father is appearing before this court with unclean hands, as he has moved without this court's permission, as I've already said. We attended mediation, which unfortunately was not fruitful. Subsequent to mediation, 3 months after the last time he had exercised visitation with the minor child, substantial visitation with the minor child.
So how long has it been since he's seen the child?
The children. His last overnight visit was February the 20th, so almost 3 months. The visitation subsequent to that was when we had mediation in the last 3 weeks. Last 2 weeks we had mediation. So when he was in town, the mother made sure that the children got to spend time with him. So that would be towards our irreparable harm, in that the kids have not been with him, do not know anything about this new home where he is. We don't know anything about the new home where he is. The kids have been reluctant to spend time with him, though I will say, and I think the mother would say to the court, that visitation did go well the days that we had mediation. Our biggest concern is that father, without any consideration for the mother and his move, after mediation didn't work out in a point of retaliation, told the mother what visitation he was going to be exercising in the near future, and that he would be exercising it in Florida, and that he would be going all over Florida, visiting different people, and that the stepmother would be around the children, even though stepmother has not submitted herself to the department as she was supposed to, or completed the tasks. I think she did one of the tasks, but did not complete the rest. So those are our biggest issues. I know that there were some issues in the home, fighting and yelling between stepmother and father. I don't think the father is going to be able to testify that he actually gets along with his wife, but their moving to Florida was an exercise in trying to avoid responsibility here in Tennessee. But again, mother's willing to work with him provided that anything is occurring in Tennessee. Even overnights for the father, if they're in Tennessee, is more than fine. But right now, until we have a final hearing on the relocation matter, we're not in agreement to allow the visitation to occur as set forth in the parenting plan. We've got 2 children in this case. One child is almost 11 and one child is almost 5. So.
Mr. Marcello, do you wish to make any sort of opening statement? I'm going to give you a chance to testify, but opening statements are usually just where you tell me what your position is. No, you don't have to be under oath.
Just for the record, Miss Duke.
Ms. Duke.
Miss Duke, the opening statement was that my wife pinched his penis. So this would be the first time I've ever heard it, and the pictures and the accusation that was made from that side was his thigh that was on the side. So I'm not sure where she's getting any type of sexual misconduct or whatever you would want to call that. So I just want to put that as a record.
Okay.
The move was planned way ahead of time. It was before, I think the accusations started October. We were planning July, August, when we first started talking about it, whenever I was talking to my brother. And I talked to Emerson about it to make sure that it was okay with her, because obviously a 30-day notice to my daughter is kind of short. I followed the parental agreement where it said to give them a certified letter within 30 days. I let her know ahead of time, and I also sent the certified letter to Whitney and her lawyer. The only thing I got back was that they didn't agree to it. I didn't see anything signed by a judge saying that I could not move. And I didn't see anything in the parenting agreement that said that I couldn't move. It's just obviously the parenting plan, the schedule would obviously not be the same due to relocating out of state. But the accusations are unsubstantiated, and it's just, for me, it's just a flashback of the first time, and I just don't know where they're getting, because I was going to bring pictures or videos of the children, but obviously with it being live stream, I don't know how about to, give evidence of Lionel before and after accusations with Tara, including Emerson, because she's in-house too. And they both enjoy being around her, and the kids have never been sent to an emergency room like they have with Whitney with an incident before. If they were sick, I brought them to the doctor. Whitney has had me, or I shouldn't say had, I volunteered numerous times to watch the kids while she was working. So there was even times where there was possibilities that I couldn't watch the kids during my scheduled time, and I would ask her if she wanted it, and she declined. So I don't see how there's a threat in the household if she's...
Let me interrupt you for a moment and explain. This hearing today is only about a motion to suspend the operation of the original parenting plan, because under that parenting plan, you were to have contact with or visitation with the children every Thursday. Oh, I'm sorry. From Thursday at 5 p.m. to Sunday at 6 p.m. every other week, and then from Thursday at 5 p.m. to the following Friday when school begins in the alternating week. And I would assume you would agree that that would not be possible if you're living in Florida.
Correct, sir.
So the hearing today is to suspend the operation of that and to determine what, suspend the operation of the parenting plan, since it's not workable if you're living in Florida, and then to determine what, if anything, what other kind of schedule would be appropriate.
Yeah.
On a temporary basis, because right now, if I rule that you are not entitled to move to the state of Florida with that because you didn't comply with the state regulations, then we'll have to do something different. But right now, the only thing that before the court is the issue of what are we going to do on the interim period until there's a final hearing. So,
I gotcha.
all right.
So the only thing I did request was after mediation, almost immediately, because in the parental agreement, it said that you have to have your week for the summer given to the other parent by May 1st, or before May 1st. So I did that, and that was the only thing I did.
All right. Well, let me hear what Ms. Duke has to say, and then we'll go from there. Ms. Duke, you may call your first witness.
Judge, I call Whitney Marcillo.
You will come around, please, ma'am. Around here, raise your right hand and be placed under oath.
Thank you.
Ms. Marcillo, is that a copy of the notice of intent to relocate that Mr. Marcillo gave you?
Yes,
Okay. And you acknowledge receipt of his intent to relocate, is that correct?
I did.
Okay. In that intent to relocate, does he give you a physical address where he plans to move?
No, it just says Central Florida.
Okay. He doesn't even give you a city, does he?
No, he does not.
And pursuant to the relocation statute, based on your knowledge of it, you're entitled to a physical address and a city where he's planning to move. Is that correct?
Correct.
All other requirements of the relocation statute as far as notice are concerned were met with this letter. Is that correct?
As far as I know.
Judge, I'd submit that as the first marked exhibit.
Mark it as Exhibit 1.
Did you agree with his notice to relocate?
No.
Okay. And did we file an objection to the notice to relocate? Gave him notice that we objected?
Yes.
At any point in time pursuant to statute, did he file a petition to change the parenting plan prior to relocation?
Not to my knowledge.
Did you end up having to expend attorney's fees in order to file a petition to modify the parenting plan because he was going to be relocating?
Yes.
And when did he relocate?
February, the end of February.
And since February the 20th, have your minor children spent the night with him?
No.
Have your children been doing really well?
They have. Yes.
Now, that being said, are you trying to keep the children away from Mr. Marcillo?
No. As when we had mediation at the end of April, I allowed him both a Tuesday evening and a Wednesday evening visit with the kids for dinner and just asked for them to be returned prior to bedtime because they were school nights.
And did you two work that out just fine?
Yes.
What is your only request mainly for visitation purposes, or what are your two requests? That they be in are you asking that the court require that his visits be in Tennessee until we get this case resolved?
Yes, I have told him that I don't have any issues with him coming to exercise anytime in Tennessee and alone, just for the safety of the kids.
And Department of Children's Services case was opened on this, is that correct?
Yes.
And there were two pinching incidences, is that correct?
No, there were multiple.
Multiple, okay. Tell the court a little bit about that.
Yes. So over the summer, I started noticing that my then 3-year-old son was having a lot of anxiety at exchanges. When I'd addressed this concern with my ex-husband, Mr. Marcillo, he kind of shrugged it off. He told me that he didn't have any of those issues, despite both of the kids calling me every time they were with him. So I let him know that I was going to choose to sign our son up for play therapy. When I signed him up for play therapy, he started telling me and the care manager and therapist that my ex-husband's wife, Tara, was pinching him. And then he had been coming home with bruises. So I asked him what happened to his thigh. He had a large bruise there. He said she pinched him. And then this was almost an occurrence with every visitation. There was one visitation where I had to bring him to urgent care and have his injuries documented because he had a mark on his chest that ended up scarring. And then he had 9 bruises over his back, on his buttocks, and his thighs.
Okay. And did urgent care contact the Department of Children's Services in order to have this matter investigated?
They said they were going to.
Okay. And did DCS reach out to you and reach out to the father, to your knowledge?
To my knowledge, they did. And then I updated them with all future incidences, like Christmas Eve when my son came home and said that the stepmom had pinched him on the penis as punishment.
And at this point in time, did you express to Mr. Marcillo that, hey, it's not an issue for you necessarily, but don't need to leave the children alone with your wife?
I communicated with DCS, and she communicated that due to our high conflict at times nature. And I know that when I have addressed certain things with him myself, it tends to come off and he can get defensive at times. So I didn't want to upset him. So I asked DCS what their recommendations would be, and I made sure that they had aligned with what I was going to say to him, because I didn't want to repeat anything unnecessarily. So the caseworker said that she was going to tell him to not leave the children unsupervised with his wife, and to make sure that he did not delegate any discipline or childcare or bedtime routines to the wife as well.
And after DCS told Mr. Morcillo that he could not leave the child alone with the stepmother, did he send you a notice of intent to move to Florida?
Yes, he also stated in parenting messages that they're never alone with her for more than 15 minutes at a time.
And during this time period, did the Department of Children's Services have things for all of you to do, for Mr. Morcillo and for the stepmother to do?
Yes, for the both of them.
Okay. And to your knowledge, did Mr. Morcillo complete what he was supposed to do?
To my knowledge.
Okay. Did Ms. Morcillo complete the task that she was supposed to complete?
To my knowledge, his wife had only completed half of them.
And when he up and moved, what did DCS do at that point?
We had been transferred to family services by that point in time, and they told me that due to the jurisdiction issue of them being in Florida, Tennessee would not be able to pay for any services due to that relocation issue, and therefore they were forced to close the case.
And at this time, are you asking that the stepmother, until she's resolved her issues, the stepmother's contact with the minor children be limited or supervised, or not at all?
I would prefer for her contact to be preferably not at all. I feel like that's the safest avenue, especially with the anxiety that my youngest seems to have at the mention of her name.
Now, admittedly, the minor children had a decent visit that Tuesday and Wednesday, or Wednesday and Thursday after the mediation. Is that correct?
Yes.
And did you receive an alarming text message from Mr. Morcillo about what visitation he intended on exercising?
He had told me when we exchanged the children after mediation that he would be exercising his week of summer visitation for his summer vacation week for the week of Father's Day. And then he sent me that in a text message, in a parenting app message as well. I asked for details regarding that, because if he was coming to Tennessee alone, I would have been more amenable. But he had told me that he would be going to Florida to exercise his time down there.
And did he tell you he would be doing this?
Yes.
At any point in time, did Mr. Morcillo come into this court and seek permission to move to Florida?
Not to my knowledge.
And based on your understanding of the statute, he would have needed to do that. Is that correct?
Yes.
Okay. Judge, if I may have one moment. Do you have a physical address for him now?
Yes, I believe he shared one.
What is your proposal in the interim to try to the visitation with their father?
I have them both in therapy. I would propose that anytime their father comes to town to see them, I mean, I'm more than happy to allow him to exercise those visits. If he is alone, I don't mind if it's an overnight visit, with keeping in mind any school days that it may be surrounding, so that they can have as much consistency as possible.
So as long as it's in Tennessee, you're okay with it, provided that he is by himself and not with the stepmother.
Correct.
For the short time period that DCS required him to supervise the stepmother with the minor children, did he follow through with that?
Not as far as I know.
Are you concerned about the health and safety of your minor children and the fact that they could be irreparably harmed if they're required to go to Florida?
Yes,
Now, you've got a minor child in school, is that correct?
I do.
Okay, and the other one is in daycare.
Yes, and he also receives speech services.
Okay. Tell the court a little bit about his speech services.
So my youngest son is 4. He goes to speech therapy twice a week. He's been in that specific speech therapy for about 1.5 years now. If he misses a certain number of appointments, then they will remove him off of their speech appointment roster, and he will be moved to the wait list, which is about a 12-month wait list at this time.
Okay, so tell the court, how often is he going to his speech appointments?
Twice a week.
Twice a week. And so if he misses 3 speech appointments in a row, so a period of 10 days, you would have 3 speech appointments. Is that fair?
I'm sorry.
In a period of about 10 days, would you have those 3 speech appointments that he would need to be going to?
Yes.
Okay. If he were to miss by going to the father's house for any 10-day period of time, would that reset him in the speech world?
It can.
Okay. Have you been the one providing most of the care for purposes of getting the child to and from speech appointments?
Yes, if it on Wednesdays, it normally happens in the afternoon. So if I'm working, I normally delegate that transportation to family.
Okay. When you heard the father say that they didn't move because of DCS getting involved in the case, that they had been planning it since August, was that a surprise to you?
Yes.
Okay. At any point in time between August and February, or between August and the time that he sent the intent to relocate, I don't have the date right in front of me. What was that date? Do you remember?
I'm not sure what the date was on that letter, but I know that he first brought it up to me in messages around Thanksgiving when he started canceling parenting time.
Okay. And at Thanksgiving, did he miss an entire 5-day period of time with the children?
Yes, he said that it was surrounding DCS for reasons of why he wanted to cancel his time, though he did ask to take them out to lunch that Saturday, which I allowed for him to do, and then returned them to me in the evening per his choice. But he did cancel that entire Thanksgiving break.
And did he miss visits off and on until February the 20th?
I don't believe he missed any visits in December or January or February, but he has routinely missed them beforehand.
Okay, but beginning February the 20th, he has not had them overnight.
Correct. Yes, he's missed all visits since February 20th.
Are you concerned for the health and safety of your minor children having to go into a home, number one, that they don't know, and number two, into the home of the stepmother that's not completed what she was supposed to complete pursuant to DCS requirements?
I am, yes.
Okay. Are you also concerned that since they've not really spent the night with the father since February the 20th, that there'll be a little bit of a readjustment when they do spend the night?
Yes, I do. And from what I have gathered at their therapy appointments, it's also a concern that's been shared and reciprocated back to me.
Okay. It's a concern of the therapist also. Is that what you're saying?
Correct, yes.
Okay. Judge, I'll tender the witness.
Mr. Marcello, you're acting as your own lawyer. You have the right to ask questions. If you want to do that, you may do so now, but they must be in a question form. I'm going to give you a chance to testify and make your statement. You have questions? All right, come up to the podium.
Before mediation, you gave a preferred parenting plan, what you would expect for out of state. And in that, you allowed 4 weeks a
Judge,
year.
I'm going to object because I think that was in.
No, it wasn't mediation.
And she's objecting. You
Oh,
wait
sorry.
till she finishes.
Judge, that was, number one, settlement negotiations, and number two, it was in preparation for mediation.
All mediation, anything that happens in mediation is confidential and is not to be introduced in a hearing. The reason for that is because under the mediation rules, if both parties have a freedom to discuss whatever they want to discuss and make offers without thinking it's going to be used against them in a proceeding, then that would make the chances of resolving the case greater. In addition, there is a rule of law that says a offer of settlement cannot be introduced in a trial. It can't be done because, again, for the same reason, it would inhibit people from trying to settle cases if they make an offer to settle that they know is going to come back against them. So
This was before mediation, and it's before any, as far as I know, before she even contacted a lawyer.
so what is it?
What the question?
No, what is it the thing that you're wanting to ask her about?
Oh, she offered 4 weeks overnight while I was in Florida, and
That's
then
And again, that's
That's
the
an
offer that you're talking about is an offer of settlement in this situation. So if
Even though it
you
was
can
before-
ask her if she was ever agreeable to you having overnight in Florida without making the actual relegation or the specifics of the order.
Ms. Morsillo, were you ever inclined to having me have the kids for week-long periods overnight in Florida?
I know that it was discussed as a possibility, but I had never agreed to that.
And there's been time, or have you ever been offered extra time with the kids and declined even after the allegations were made?
I mean, I
I'm
normally,
going to object as to relevance. I don't know what relevance that has.
What's the relevance? Relevance means that the information you're seeking would make something more likely true or not true.
Yes, I'm trying to prove a point or give information that the safety of the kids is not her first concern. So whenever she was given an opportunity to keep the kids allegedly safe, she declined.
Well, I'm going to overrule the objection and allow it to come in. It may not be relevant, but we'll see. Go ahead.
I've offered you times, or there's been times where you've been offered extra time due to conflict in my schedule, and you declined it and saying, no, you should watch the kids. So why didn't you allocate that time to yourself if the kids were threatened?
I don't remember any time that I've declined receiving more time with the kids outside of one day where I was out of town, and that was July of 2024.
Do you recall the weekend that you made the first allegations of child abuse in my household and Tar's household, Tar Morsillo's household?
I mean, I don't remember the date, but I know it was around September, October.
Okay. And was that the same weekend that your biological mother and stepfather came to visit?
I don't believe so. I thought they were in town the following during the fall break period.
Was that also the same weekend that you broke up with your fiance? Tyler I don't know his last name, but I know his name is Tyler, and I'm assuming it's the only fiance that's named Tyler.
We weren't engaged. We were just dating. However, no, we did not break up that weekend.
Okay. The first allegations that were made, Lionel had pinch marks on his thigh. Is that correct?
Yes.
What color were the bruises from the pictures of Madison?
When I noticed the bruising, I believe it was purple.
I want that for the record.
What?
That-
For the record?
She's claiming that the pictures that were provided were purple bruises.
What?
Purple? The bruise color was purple.
Okay.
So I just want that for the record that so, sorry, I'm a little nervous. Since I moved to Florida, your claim was that the kids are happy and carefree. Does our daughter Emerson Morsillo text me claiming that she misses me?
As far as I know, I don't check her text messages routinely.
she has a smartphone, correct?
Yes, she has an Android.
Okay. As a parent, you don't feel there's a need to check that phone because she has a smartphone and she has access to things that she shouldn't?
It has parental controls on it.
And what do those parental controls monitor?
It monitors any contacts that she adds, so all of her contacts are approved through me. It monitors all of the access that she has to various apps. She does not have internet access on there. And then her photos are all backed up to a Google Photos so that I can monitor things that she's doing as needed, but she's been very responsible, so I don't feel the need to essentially look over her shoulder for every single day.
The first month of March, or not March, the first month I was gone, which was March, Lionel had his tonsils taken out.
Yes.
Did Lionel call me 2 times within 2 days, crying that he misses me?
Yes, he had a very hard week. He was on recovery for 2 weeks. He felt it was unfair that you were not in person for him when he was having a lot of pain. So I offered to FaceTime you to see if that would help him feel better, to be able to see and connect with you there.
On occasions, Emerson, who has freely use of her smartphone, is approximately maybe 20 feet from Lionel's bedroom when we were living in Franklin, Tennessee. At any point, did Emerson make any claims that there was abuse going on?
She told me that she was in her bedroom all weekend when she was at your house, and that if Lionel came into her room, that she was told to keep the door open, and frequently y'all would come in and take Lionel out of the room if you heard him talking on the phone. So she was unable to provide any kind of knowledge of that kind to me.
On the parenting app, everything is recorded, including what you would call video time. It was being recorded, to your knowledge, correct?
Yes.
Was there a night where you tried talking to Lionel and he declined, and he specifically said he did not want to talk to you?
Yes, I believe there was a moment where he had been upset or tired. I know that he had been, if it was the weekend after Christmas that you're referring to, that's the weekend that I'm referring to, and I had been on an airplane, as well as out of town that weekend. And he had called me, but he had seemed quite tired and upset. So
Before allegations were made, I believe September, October, I don't know, officially documented with DCS, it was October 14th that she reached out to me. Were you confused as to why, with all the hearsay or documentations from Lionel, that they did not stop parental time with me overnights?
no, the DCS caseworker explained that due to the fact that you had less than 50% of your parenting time and had been canceling your Thursday overnights for over a year, that they were not able to put a safety plan into place to limit the custody time.
With the changing in parenting plan and your documentation to the courts, you mentioned that I verbally changed the documentation. Do you feel like you partaked in that specific changing of the plan?
I was in agreement to keep the kids on every Thursday overnight and then move your every other weekend from Thursday evening to Sunday evening to Friday after school to Monday morning, because I felt that it was in the better interest of the kids because they were less tired and Emerson's grades improved in school.
And with that change of the agreement, why with your lawyer would you say that I, myself, and not we changed the parenting time with the children?
I think she can answer why her lawyer would do something.
I don't believe.
Why?
I don't think she can answer the question that you're asking, which is why her lawyer would have said or done anything, unless she told her lawyer to say it. You can ask that question.
Did you tell your lawyer to write that I alone changed the parenting agreement?
I mean, I don't recall.
I don't think that's been said anywhere.
Don't think what?
I think that's been said anywhere.
It was said in the first documentation that she sent me the first time, whenever relocation was mentioned. It's in the court documents filed with Lynn Collins. She's the only name I remember on the document.
Well, I don't see how it's really relevant, so let's move on.
Okay. Do you feel that I have the best interest of the kids?
No.
And why would that be?
I don't feel that you have the best interests of the kids in regards to keeping them safe when your wife is around.
So you would claim that I would put Tara Morsillo ahead of the children's safety?
Yes.
Is there a reason why you would feel that?
Because our youngest son has had countless bruises coming home from your house despite DCS involvement. You relocated despite my objection to the relocation to Florida, instead of allowing her to complete the DCS task requirements. The main piece of which she did not complete was the parenting assessment with the parent observation that would allow a DCS caseworker to see how the kids interact with her in person in real time.
So it would be safe to say that you feel Tara and I have dodged DCS and for the 1 week family services?
Yes, but family services was involved for about 2 months.
Their communication was only maybe a week.
Can't testify, you're asking questions.
So with DCS's involvement, they claim that there was no threat in the household and that the most she would do was implement best practices. Were you aware of that?
That is not what they'd shared with me.
Are you aware that the only thing that Madison said for our household was for myself to make sure that I put Lionel to bed? And if there is any discipline outside of obviously any type of physical, which is not allowed, but any type of discipline that I would be the one to administer. Were you aware of that?
I'm aware of what she shared with me, which was those aspects and then additional.
Your assumption is that there was a delay in us taking the assessments and evaluations. Is that correct?
I'm not sure. I know the DCS had a delay in scheduling those services and getting in contact with the practitioners who did the assessments and observations.
Why would you assume at that point then that in your paperwork that you filed that we were dodging DCS then?
Because you moved before tasks were completed.
That's not. That's all I have, Your Honor.
All right, thank you. Anything?
No follow-up.
Thank you, ma'am. You may step down.
Thank you.
Ms. Duke, you have any other witnesses?
I don't, Your Honor. That's our proof.
Plaintiff or the petitioner has rested their proof. If you wish to testify, now would be an appropriate time. Do you want to testify? All right, then come forward and raise your right hand. Raise your right hand and let the clerk place you under oath. All right, thank you. Have a seat. This is your opportunity to testify about the circumstances and what's being asked here. So I'll hear whatever you have to say.
With Whitney, ever since we first separated, there's been friction when it comes to co-parenting. Whether it's she feels what's best for the kids or what I feel is best for the kids. There's a track record of people that have any friction against Whitney that she will try to block them completely out of the kid's life. She had friction when her mom testified against her, and she tried everything to...
Judge, I'm going to object if this is outside the scope of today's hearing, which it is, if it goes back farther than...
All right, keep in mind that the sole purpose of this hearing is for me to determine what should be your schedule with the children since you have moved to Florida. You have moved to Florida, correct?
Yes, sir.
And that because you have moved to Florida prior to getting court authorization, then the now question is what schedule is going to apply and where you're going to exercise your visitation. So anything else is not really relevant about that. Your past history is not relevant unless you have some reason to believe that it's relevant. So relevance means that it's something that's important to or makes more likely to be true a fact.
Okay, I'll stick just to today then.
All right.
I feel, and when we go to a final hearing, I could provide plenty of evidence of the kids happy, healthy, and wanting to spend time with Tara before and after any allegations were made, even to the most recent month of February. DCS, I had regular contact with DCS. I never dodged a phone call, never dodged a text. If anything, I was the one that was pursuing information from DCS to try to ensure that everything was going streamlined so we could get some normalcy at the house, because allegations of any type of abuse is obviously serious and is not in the norm for a normal household. Myself, I fortunately was able to establish a late night phone call randomly on a Saturday night from the person that administers the first evaluation and assessment. And she was able to get me in really, really quick. Tara's was not able to be scheduled until I think it was 2 months prior to them assigning that to them people. Tara Morsillo made multiple attempts to try to get it moved along faster since Madison kept asking us, when are we going to get done? Do you know when the schedule is? We were open to DCS on the first day. She asked to visit. We made ourselves available, even though Tara was working. She stopped work to accommodate time for Madison. Madison found no threats in the house. The only pictures she showed us of child abuse were brown marks on Lionel's thigh, and she said it was bruising from pinching the allegations. I made a statement to her that brown bruising is not a couple days old or even a week old. I'm not a medical doctor, but I can tell you brown bruises just from growing up the last 44 years is usually over a week old bruises. She said that after that allegation, there was more allegations, and that she was needing to follow up. She was trying to close it, but she said with the outside source, she still had to investigate. So by that time, I believe I had finished all my assessments and evaluations. Tara did her evaluation, even though we did note with DCS that we're not sure if it was the right one. Madison explained that it was very frustrating trying to deal with the outside sources. There's proof that Tara, on the day that she was scheduled, did her assessment. There was no delay in it. Whenever I contacted Family Services, and I'm the one who reached out to Family Services, I talked to Dana, who was handling the case. She said that she would have to get back with me. She got back with me, and she explained that since we moved out of state, that the state would not pay for, or TennCare would not pay for the classes. I offered to pay the classes myself, but she said that she doesn't see a problem. Both her and Madison said that.
I'm going to object as to anything else they said, if it's recommendations, Judge.
All right, the objection is to hearsay, so I'll sustain the objection. Where did you move to in Florida?
I provided documentation the first time to 2060 Canopy Boulevard, DeLand, Florida.
Delaney, Florida?
DeLand, D-E-L-A-N-D.
Okay.
Sorry, my voice is a little scratchy.
Why did you move to Florida?
There's multiple reasons. We kept on visiting my brother in South Florida, and he's the only family member that I have left. My past career and all my friends are in Florida, and whenever I was talking about moving back, I got multiple job opportunities to go back. One was going back to something I was kind of used to before I met Whitney, and the other one was more like a passion, but I would be able to have great opportunities in that. And it was not to dodge DCS because I complied before anything ever happened. And I mentioned it to DCS that we were planning on moving, and her recommendation was to, obviously moving out of state, I wouldn't be able to follow it all, but try to accommodate the schedule the best I can until there was a hearing on a revised parenting plan. Tara and I have always provided the kids with a happy, healthy home. They've always had their own room, which was which was in the parenting plan, which Whitney also failed to provide. And even when we relocated, we ensured that both children had their own room as well. To accommodate Lionel, I've reached out to multiple speech therapists, and if they aren't inclined to do it on the weeks that I would have the kids, then I would do virtual or get the worksheets for Lionel's speech therapy, which whenever I attend his speech therapy, I get usually it's just a piece of paper, but it's the words that he's practicing for that week or for that month. And during the summer is usually whenever I'm able to take him to his speech therapy, because usually it's during the week and I don't have them during the week. And the only time I've ever altered any of my parenting plan prior to the move was Lionel was having difficulty with me handing him off to his mother, which is documented on video as well. He did not want to go to her, and to provide an agreement between both parties was to provide less handoffs, that I would switch from, instead of Thursday to Saturday, that I would switch from Friday to Monday. And the kids never struggled to wake up for that hour earlier, because we were living in Franklin. So it was like a 50-minute drive to get to her school. The kids never struggled with that. Lionel has always been provided ample time for his speech therapy when he's with me. The speech therapist explained to me that he was not getting practice at home, and that's wherever I first.
I object to that, Judge.
Okay.
It would be hearsay, sustain the objection.
So when Lionel is with me, I do go over speech therapy with him. I've explained that to Miss Morcillo, Whitney Morcillo, and she does not like that I practice, and she asked me to not, basically not acknowledge any of his speech impediments, that it would make him self-conscious. Other than that, DCS and Family Services never saw a viable threat in my household, even with, I'm not sure what was ever given to them. I've never got documentation from DCS or Family Services, but up until February, the end of February, they never once intervened with my time with the kids, and the documentation with them was there was no threat.
Well, you knew what your parenting plan provided for you in the way of visitation with your children, and you knew that before you moved, correct?
Correct. I knew
What
that.
did you envision was going to happen if you moved all the way to Florida when you had that type of visitation?
I had hoped that Whitney and I could co-parent and figure out what was best for the kids.
Because what would that be? If I'm asking you, what did you
So,
envision would happen?
Originally, it's hard to say it if I can't mention the offer before the lawyers were involved.
No, I'm asking you what you envisioned.
So I envisioned, like what was mentioned before, less frequency, so less handoffs with the children, and I would be able to, since it would be prolonged periods other than the 2-3 a day overnights, that I would have better quality time with the kids.
And how old are your children?
Emerson is 11, and Lionel is 4. Sorry.
So your oldest is in school.
Yes, sir.
And during a school year, what did you envision would happen as far as your visits with her?
My recommendation, I'm confused on answering that, but I guess you'll stop me if I'm saying anything wrong. My time that I recommended did not interfere with the children's school. It was an alternating spring break, since it's only 1 week. It was 1 week for fall break, since there's 2 weeks. 1 week for winter break or Christmas break, because it's 2 weeks. And then the only thing we weren't able to decide prior to mediation was the length of the summers. And she recommended 1, and I wanted more than just 1 week. And the only thing we did different was, instead of me doing a week where the children were dropped off on like Sunday and then school starts Monday, that we would give them time between so that they would be able to adjust back to the schedule. And that was about as far as we got before lawyers.
So your vision was that when you moved to Florida, you were not going to see the children as frequently, but you were saying that you would have longer periods of time.
A better quality of time with them. Yes, sir.
All right.
You're
Anything else you want to say before we move forward? Ms. Duke is going to be able to ask you some questions.
I wish that Whitney and I could be better co-parents.
What?
I just wish that the two of us could be better co-parents.
Okay.
You stated just a minute ago that Emerson is 11, but do you know she's 10-year-old?
10, sorry.
Okay. And you stated that you moved to Florida to be closer to your brother, but you moved to Central Florida, which is about 6 hours from South Florida. Is that right?
It's not that far.
It's a significant distance, though, isn't it?
For the way I drive and travel, that would not be significant for me. A 4-hour drive or 3.5-hour drive is not a lot.
And sir, you said you moved there for job opportunities, but you're actually working at a fish aquarium store right now. Is that right?
That was one of the opportunities I mentioned before.
And you're making minimum wage there?
No, sir.
Okay. What, are you making more than you were making when you were working in Tennessee?
Before I left Tennessee, I was not working, so it is more. But it's not more than whenever I left Specialty Electric.
Because, sir, you were trying to get away. It wasn't that you had a better opportunity, because you didn't have a better opportunity at a fish aquarium store in Florida, did you?
Yes, because it's a passion of mine, ma'am.
Okay.
Miss Duke.
How much are you making there?
I make $17.50 starting off for the first month.
And how much did you make at Specialty Electric when you were here?
23.
Okay. And so you've gotten a better job opportunity in Florida.
Yes, ma'am.
That's your statement to this court.
Yes, sir.
I'm sorry, how
And
much do you make in Florida?
$17.50 at the current moment.
he was making 23 at Specialty. And you're so involved with speech therapy here, right?
Sorry. Speech therapy is usually during Miss Morsillo's time. That's where she scheduled it.
Okay, but you said that you've worked with the child, you've done all this with speech therapy.
Yes, she even asked if I could provide documents to her that were given to me by the speech therapist.
Okay, what's the speech therapist's name?
It changes every few months.
Give me one of them.
I can't recall at the current moment.
Give me one name out of the 4 or 5 that this child's seen.
I can't recall. I've
Because
only
you've
met
not
them.
been involved, have you?
I have been involved with his speech therapy, ma'am.
And then you said earlier that you've not forfeited any of your time, but you have in fact forfeited your every other Thursday to Friday, haven't you?
Yes, whenever we made an agreement that we would do the schedule that we both agreed upon.
So you forfeited that time, and then you just up and moved, and since February the 20th, aside from Miss Morsillo making sure you saw them when you were in town, you've not seen your children.
I asked to see the kids. She did not offer the time. She agreed to the time, but she did not offer the time.
But she made sure to deliver them to you and pick them back up, right?
Yes, ma'am.
Okay. Does she get any credit for that today?
Absolutely. She could have declined it.
Judge, that's all.
All right, thank you, sir. Step down. Do you have any other witnesses? Ms. Duke, do you have any rebuttal? And I'll hear you in argument.
Briefly, Judge, the father moved without permission of this court, and the father did not have good reason to relocate to Florida. He said he had better job opportunities, which is not accurate. He said he was moving to be closer to family, but I'd submit to the court that 3 to 4 hours away from family is not enough. The father has slowly forfeited parenting time through today's date. And I do not think at this point in time that it is in the best interest of the minor children and could potentially cause some irreparable harm for the minor children if the father continued to exercise the schedule which is currently in place. I would ask that pending a final hearing that all visitation occur in Tennessee. While the father wants to purport that he's a good father, I mean, he couldn't even name one of the 4 or 5 speech therapists that the kids have seen. And he couldn't even tell you what the child's age is. So at this point in time, I just ask that the court limit all visitation to be in Tennessee and that it be on maybe an every other weekend schedule or something like that. The mother's not opposed to it being the same schedule, provided that it's in Tennessee away from the stepmother.
Mr. Marcello, do you have anything else you want to say?
I apologize for saying that Emerson was 11. It's just obviously
That's
representing
not a big
myself is
deal.
nerve-wracking, and it was because of the prior case that was in here because their daughter was 11. It just came out 11. I am not a threat to the children. They will say I'm a threat to the children, but they constantly will tell you that whenever Tara's not around, there's never any problems. They'll claim that I've given up time, but at the same time, Miss Morsillo has asked me to take the kids on multiple occasions, and even to the point where I had to bring babysitters to my house that I did not know just so she could go to work. But yet I'm a bad parent, which is not the case. The fact is that the kids do want to see me. The fact is that the kids do want to see Tara. Tara just told Whitney to get out of her car, and from there on, that point, that weekend is when the allegations have started. She's blacklisted like anyone else who's been any friction against Whitney.
You are testifying rather than just giving me your final statements.
Yeah. The fact is that DCS, Nor Family Services, who both had my phone number, both had my email, both were provided addresses along with Whitney and her lawyer prior to the 30 days, and a physical address of that fact, 2060 Canopy Boulevard, or Canopy Terrace Boulevard, DeLand, Florida, was required. When I consulted a lawyer, I was told I was allowed to move, and I've interpreted that the documentation that I got didn't have a judge's signature on it. So I assumed that I was able to move since Ms. Morsillo or Whitney Morsillo offered a schedule that was out of state. When it comes to the job opportunity, I understand that it's $17.50 an hour. But just like whenever other people pursue certain paths, the pay obviously starts off low. Just as Ms. Morsillo pursued English as a passion, I pursued a passion that would make me happy and long-term would give me stability. I have never missed child support. Every tax year, I was able to claim Emerson due to the fact that I've always been caught up on child support. I don't dodge it. There's a couple of times where it's been behind by a few days, but that's something that I cannot do or I cannot help because I go through the Tennessee website to provide that. Even whenever times I was unemployed, she still got her child support, and I just used my savings to pay child support. I've offered multiple times to take the kids as well. That wasn't my scheduled time. So it's not like I'm trying to dodge time with the kids because I do love my kids. There's a reason I adopted Emerson. There's a reason why I cherish Lionel. They're my kids. I protect them. They've never been in harm's way. If there was ever any harm to my kids, it would be taken out of the equation. I would not ever put my kids in harm's way. Whether it be a wife, a brother, a friend, a stranger, it would be the same result. They would be taken away from that situation. And that's all I have, Your Honor.
Thank you. This is here today solely on the motion to suspend the visitation that was set forth in the final decree of divorce and the parenting plan that was adopted and agreed upon by the parties at the time of their divorce, pending a final hearing. And the court finds that by the admission of both parties, both Ms. Marcellos and Mr. Marcello, both of them agree that the prior plan is not workable on a temporary basis. And for that reason, the court grants the motion to suspend the court-ordered visitation set forth in the parenting plan pending the final hearing. Now, then the issue becomes what schedule shall Mr. Marcello have with the children, and how much time should he have, and where should he exercise that time, and under what circumstances? The problem that we've got in this situation is that you have one view of parenting, and your view of parenting is that it's okay to give up the weekly contact with your children, one of whom is fairly young, and move hours away, and then without permission from the court, and then instead of having that regular visitation on a weekly basis where you saw your kids every week, you're then going to have extended periods further apart. And I understand that when you calculate the number of days, that may be in your mind the same amount of time. But for young children, this court is of the opinion that frequency of visitation especially is more important than oftentimes the length of visitation. There is enough evidence in this record to indicate to the court that where DCS was investigating this case and was making recommendations for you and your wife, and apparently you followed all of the recommendations, but your wife had not completed everything one way or the other, then your wife had not basically fulfilled it before you moved. there is an inference there that the reason for your move may have been more related to getting away from the Department of Children's Services investigation than your professed desire to be closer to your brother, who is still many hours away from you or several hours away from you. I'm of the opinion that on a temporary basis, the schedule that Mr. Marcello shall have shall be 1 weekend per month from Friday until Sunday, Friday at 6 to Sunday at 6 in the state of Tennessee. He can exercise that in Dixon County or Davidson County or any of the surrounding contiguous counties if he wishes to do so. Pending a further hearing before the court, and I don't have Mrs. Tara Marcello before me for me to make any determination about her character or her trustworthiness, then I cannot, and in view of the Department of Children's Services recommendations not allegedly having been fulfilled, then I must, at this point, order that she's not to have any contact until a further hearing before the court, in which time this court will consider whether or not she has completed any of the things that the department wishes or wanted her to do. I'm not saying your wife abused the children, but that was the allegation that was made, and until the allegation can be fully investigated and all of the recommendations followed, it is my belief that the children's best interest requires me to protect them against any potential. I don't know your wife, and as a result of that, I'm not trying to make any false accusations about her, but I can guarantee you that there are plenty of situations where one spouse or one partner thinks that their partner is a good parent and a good caregiver to their children, only to later find, unfortunately, that that was not the case. I've got a case over in Dixon or in Cheatham County where a father allowed his girlfriend to provide care for his, I think it was 6-year-old son. And he thought everything was fine, that she was taking good care of him. She beat that child every day of that child's life for months until the child died. And fortunately for the world to know, that was captured, a lot of it was captured on video because she took the child to work with her. And as a result of that, father supposedly thought that she was doing a good job of caring for the child. My point in making that is not to say that that's a direct correlation to your situation, but it's to give you an illustration of why, after all of these years of doing what I do, that I'm going to err on the side of protecting children, even if it is an inconvenience or a problem for the parents, because the children didn't ask to be put in this situation. So my ruling is on a temporary basis, it's 1 weekend per month. I would like to see Mr. Marcello have some extended time with the children, but as quickly as we can do, we're at the beginning of the summer. I would think before the end of the summer, there should be enough evidence about Mrs. Marcello that would allow us to consider giving him an extended period of time in Florida with the children rather. So I just think if you talk to Ms. Duke and find out what they're needing to satisfy them, then whatever you two can agree upon, it would be fine with me. But I do envision that it would be good for the children to be able to go see their father for an extended period of time in the state of Florida once he's established and has everything set up.
One question I have for your honor is, based on the fact that it would be a new place for the kiddos, would it be possible to have a short visit? Like when we're coordinating, it makes more sense to have a little short visit, mom be down there, and then maybe extend it if it's going well.
Turn his microphone on. There's a microphone in front of you. Turn it on.
To answer your question, one of the recommendations that I was giving, and I'm pretty sure I provided it to Whitney as well, was that we had agreed upon spring break for the most part, winter break and winter break and fall break.
We can talk about this from here.
But,
I was just looking for direction from the court.
I did recommend that it started off slow, and each year it would increase.
And I think that's a reasonable position to take. What I'm saying is right now, your visitation is going to be 1 weekend per month in Dixon or Davidson County, one of those contiguous counties. But it should be possible for you two to work out an extended period where maybe a weekend occurs in Florida rather than, you having to come up here, then she can bring the kids down or y'all can meet somewhere or something on that order. But I would like to see them get acclimated to your new home. You're a father. You have the right to have your children with you. I may not agree with your decision-making, and the fact that you moved without getting prior approval of the court is part of the problem that you're facing right now, because once you submit yourself to a court because you two can't agree and the court has to put an order down in a parenting plan, you're bound by that order and parenting plan. And that parenting plan requires you to file the notice. And if you don't get an agreement, you have to file something in court and get an approval of the court before you move. And you didn't do that. So that's the reason that you're suffering now with only having to come up here during the time. So,
Judge, are you giving us a little bit of purview on the visits here? If part of the DCS requirement was for them to be able to lay eyes on Tara interacting with the children. So as long as mom approves of it to get that portion of it completed, the no contact, if
my no contact is because there was not a completion of the Department of Children's recommendations and there was some concern. I have no reason to believe that Ms. Tara poses any danger to these children, but that's the problem with being a step-parent. When you're interacting with children that are not your own and you're bathing them or dressing them or doing whatever, and, you accidentally pinch one of them or you accidentally do something, it can be misinterpreted. Can be a difficult situation. So I think as long as Ms. Whitney Marcello is satisfied that Ms. Tara has met whatever conditions are, and then you two can agree on it, then that will be fine to put an order down that suspends or does away with my no contact order. So
Okay.
my no contact order for Tara is only until there's been some inclination or some completion of what the Department of Children's Services had in mind during their investigation. And put that language in the order.
I'll be happy to.
All right. All right, anything else?
Nothing else.
When it comes to the recommendations of, I guess it would be family services or back to DCS, but they both, one shifted the case over to, or DCS shifted it over to family services and family services closed it. Is the proof that you guys needed something that's automatically given to you guys, or is it just provided to us?
You need to talk to Ms. Duke because there's.
We'll just have to coordinate getting the case opened back up to do what we got to do. I can do that.
All right,
Thank you, Judge.
we are.